you're going to need to take the name of the spouse or of the Medi-Cal applicant off their assets once they've qualified for benefits, so off the bank accounts and that type of thing. Normally you can't just do that. So the way estate planning can work is that I put in provisions in the trust and the power of attorney that say if you're in a skilled nursing facility, or could be in one within four months or so, that whoever you've named to make decisions for you can transfer assets into their name. So they can take it out of your name, okay? And if you're already qualified, it's not a big deal, it's not like you're doing anything wrong. So that's one way that it can benefit you, okay? And the other thing that it can do is, it can say that if you need skilled care, you can have some of your assets spent on things other than your care. And by that I mean, instead of them just writing an $8,000 check every month, maybe they put some money into your house, replace the roof or something like that. So they're spending money, but they're not necessarily spending it on care. So it allows them to spend down assets in a way that's going to ultimately benefit the estate, and then you can qualify for benefits. It's not going to just say, normally the trust would say, well, if you have these issues, all your money needs to go pay for your care. Okay? So it would in essence accelerate Medi-Cal eligibility. The other thing that it can do, and in California is unique in this, and this will not be applicable after another 6 to 8 months, is typically, if you give money away and you want to try to apply for Medi-Cal, they're going to apply what's called a penalty period, and that means basically for every $5,000, it's $5,500 or so, but we'll just say 5. You can't apply for Medi-Cal for 1 month, okay? What California does is they look back up to 30 months for all the money you may have given away, and what they do then is they say, okay, well if you gave away $5,000 3 months ago, you're ineligible for 1 month from the time that you made the transfer. Okay? So if you made the transfer 3 months ago, you would have had to have waited until 2 months ago before you could have applied for Medi-Cal. Okay? In every other state, currently, they go back up to 60 months, 5 years, and they will add all the gifts together that you've given and then do your period of ineligibility. California still, again, looks only 30 months, but what they do is if you gave away, let's say, $100,000 at one time, you would basically have to wait 20 months before you could apply. But if you instead gave away $100,000, but you did it $5,000 a day for 20 days, each of those transfers is going to be dealt with separately. So it's going to generate a 1 month period of ineligibility. So basically, you'd have, let's say, here's the 1st, 10th, 20th, right? So the one transfer you make on the 1st is 1 month, the one you make on the 2nd is 1 month. So basically these things are staggered, so you've made these gifts every day, but you're only generating 1 month of ineligibility for Medi-Cal, even though you've given away $100,000. Now that rule is dumb. I'll be the first to tell you that it's a stupid rule and it makes absolutely no sense. But that's what the rule in California is. So when you hear these things about millionaires on Medi-Cal and that type of thing, that's what they're talking about. It's someone who has literally taken $1 million or more and just given it away, but they did it in a way that the state allows you to do in order to qualify for benefits. Now, I'm not saying that's what you should do, okay? But I do put in the ability to do that if it's necessary, okay? And for me, if someone comes to me and they have $1 million in the bank, I say, just pay for your care yourself. But if all they had, they've worked their whole lives for is a couple $100,000, they have a spouse, I don't have any issues in that time with saying, hey, this is what the law says that you can do. Do it. Or let's put in the provisions to do it, at a later point. But so that's, how for seniors, in particular, how these types of documents can benefit them during their lifetime. Because normally, if you don't have those kinds of provisions, you have to go to court and convince the court to allow you to give assets away or transfer assets. And then the other thing that I typically do if I'm dealing with long-term care issues is not only are we dealing with eligibility for Medi-Cal, but we want to make sure that when you die, that the state can't come back and go after your house to be repaid. Okay? Because if you own anything at death, Medi-Cal has the right to be reimbursed, and that's fine. But Medi-Cal also says that you can transfer things such as your house, and as long as you retain the right to use it during your lifetime, you can give it away. Okay, and that's right in the law. It's in the Health and Welfare and Institutions Code. It's very clear that you can do that. And so what I often do is set up irrevocable trusts for people where maybe we put their house in an irrevocable trust so that when they die, Medi-Cal can't go after it, but the house gets the tax benefits of being owned at death and that type of thing. So again, that's a benefit that can, extend during the lifetime of the person. Again, that's not for everybody. It's not for someone who's going to sell their house or is interested in a reverse mortgage or those types of things. But for certain people, that makes sense to do. Okay, a living will actually is dealing with its instructions to your physician as far as what you, and that's a common misconception that they assume it has something to do with their stuff, their estate. But it's actually, it's a directive to your physicians as far as what type of end-of-life decisions that you want made. Do you want to be kept alive as long as possible? Do you not want to be kept alive if you have an incurable condition or you're in a coma and those types of things? So that's what a living will is.
It has nothing to do with estate planning.
Well, it does in that, it's a document that's part of the Advanced Healthcare Directive, but it has nothing to do with your stuff.
You mentioned that for the Medicare, one item is not the exception item?
Exempt.
Yeah, okay. You mentioned only term insurance. Let's see if somebody has a whole life insurance, it's not going to be...
It will be a countable asset to the extent that the face value is over $1,500, which it typically is. And so what they will look at is the cash value of that policy. And so a common Medi-Cal technique, if it's appropriate, is you can borrow against the cash value, zero it out, and use that money to, again, pay for upgrades to the home or something like that, or you can just surrender the policy. There's a lot you can do with it, but it is a countable asset.
Are you allowed to deduct any expenses that you have to pay to maintain your assets within the living trust?
No. Again, as far as tax purposes are concerned, a living trust is treated by the IRS just as if you own the house outright and there was no trust. So whatever you could deduct before, you can continue to deduct. You don't get any added benefits of doing that. And it's also not a way to protect your house from, your estate from creditor claims or anything like that. I've had people tell me that, well, their friend said if you have a living trust, then when you die, your bills don't need to get paid. Well, your friend's wrong. I had one client say, well, I heard that, when you die, you don't have your estate doesn't need to pay the mortgage. No, you don't need to. The bank's going to take the house back, but you don't need to pay the mortgage if you don't want to.
Can you, are there any structures where you can transfer some of your money to your children and have a living trust for them so that you get to use them till that, so they don't have to tax it later?
That is getting into a little bit more advanced planning concepts, but yes, there are ways that you can set and put money aside for your children and keep it in trust, okay? And if they die or something, it can go back to you, or it's set aside for them, but maybe you retain the right to use the income for lifetime. There's a lot of things that you can do. You can put aside money for your kids or have it in trust until they die. So that if you have a child that maybe is not a special needs child, but maybe has other issues, drug use, or they're just really irresponsible, and so you don't think they're going to be able to handle receiving money outright, you can keep it in trust for them until they're dead. And so that
I want to use it myself, but I just as a tax planning tool.
there are ways to do that. And that would be something that Rhonda would be involved. Someone like Rhonda, who's a tax attorney. I come up with the plan, or work with the client and the CPA and come up with the plan, but I don't do the actual tax calculations typically.
Can I make a living trust for a nephew or niece?
If it's their property, they have to do it themselves. You can set up a trust though and name them as the beneficiary of your property. But you can't do it on behalf of someone else unless they've either given you power of attorney that specifically says that you can do it, or if they're incompetent, you've gone to court under a conservatorship and then asked for court permission to do it for them. But generally speaking, no, you cannot do it for someone else.
What's the minimum age for creating a living trust? Can I make a living trust for an unborn child?
Well, again, you know, if you mean for them to be the beneficiary of it,